You should also note that the CCAA, the Companies Creditors Arrangement Act, has specific provisions dealing with bonds, and those would be applicable to a sukuk kind of structure where you've got the special purpose vehicle here and the investors out to the side. And that's really you could apply those bond provisions of the CCAA to that kind of a structure. In other words, it allows the SPV to exercise the rights of the investors, apart from the right to vote on proposals. The other statute we have is the Bankruptcy and Insolvency Act, and that's typically thought of as the liquidation statute. In other words, if a company is not going to survive and restructure, then that's the statute you use for liquidation. But there are also restructuring provisions within the BIA, specifically dealing with proposals. And there are also receivership provisions within the BIA. In these recent set of amendments, there's been an implementation of what's called a national receiver provision. So if you're a secured creditor, you have the ability to get the court to appoint a receiver with power across Canada to realize upon assets. Lastly, it has to be remembered, obviously, that Canada is a federal state, so property is a matter of provincial law. And so in each province, you're going to have personal property legislation, which will determine things such as whether you've got security or whether you don't. So the issue of being a secured versus an unsecured creditor is really generally a matter of provincial law. But I think apart from Quebec, the provinces are rather similar in that regard. To get recourse to Canadian insolvency laws, it depends on the location of the debtor and the location of the collateral. So if you take a sukuk structure where the obligor is in Canada and the assets are in Canada, then the restructuring is going to be governed by Canadian law. And in fact, you're required under the CCAA to file in the location, the primary location of the debtor. The Bankruptcy and Insolvency Act and CCAA are federal statutes. So, for example, if you have a debtor in Canada that has assets across Canada, if the proceedings are in Toronto, those court orders are effective across Canada. You don't need to go to separate provinces to get your orders enforced. As I indicate here as well, the location of the SPV is not likely to be material in any kind of an insolvency, because the SPV will be a creditor of the debtor. Foreign SPVs have as much standing in Canadian courts as Canadian creditors do. So it's perfectly acceptable to have a structure where the SPV is offshore, and the SPV can participate in the insolvency proceedings. The last point, obviously, is that the creditors with the largest economic interest have the greatest say, assuming that they've got a priority interest. So obviously secured creditors get to speak first and have more sway than unsecured creditors do. Now, if there is an insolvency of a sukuk, of an obligor, which would affect a sukuk, the way a Canadian court is likely to analyze this is obviously to try to analogize the sukuk structure to accepted common law categories. And the most important distinction is secured versus unsecured creditor. And this goes back to what Jonathan said in terms of the fact you've got to look at the sukuk structure and determine, for example, is this a true sale? If the sukuk structure is based on a true sale, then the SPV is likely to be treated as a secured creditor. It'll have a proprietary claim in the assets, and therefore you'll have higher priority than under an unsecured structure. The sad reality, of course, is that secured creditors come much before unsecured creditors. So if you have a sukuk structure based on unsecured debt, then you're going to be subordinate, and unsecured creditors, with very few limited exceptions, are all on the same plane. So if you're an unsecured creditor, you're in no different position than any other unsecured creditor, such as a trade creditor. Depending on the particular structure if it's secured, depending on the particular structure, like if you've got a lease structure, whether it's a true lease or a financing lease affects how it's treated in the CCAA process. I don't really want to go into a lot of detail about that today, but essentially there are some benefits to having a true lease situation. For example, that payments for use of the collateral have to be made during an insolvency proceeding. Just to sort of wrap this all together, clearly the Canadian insolvency regime is robust, and a sukuk should have no problem exercising its rights the way any other creditor would. As I indicated before, typically in this kind of a proceeding, the SPV would be the one that would exercise the rights of the sukuk certificate holders, except for voting on a plan. So obviously the sukuk would lead the charge, and then the investors would still have a vote later on. I've looked at a number of decisions that have been rendered by other courts in compliant financings, and I'm sure you're all familiar with Beximco, East Cameron, and the investment DAR cases, two of which were in the UK and one of which was in the United States. And I think that the principles in those cases would be applied in Canada. Canadian courts in insolvency matters are very, very practical. And the benefit of that is, like, for example, the CCAA is quite a brief statute. It's a lot longer than it used to be, but it's quite a brief statute. And what that does is it allows judges to essentially fashion a remedy that is appropriate in the circumstances, which respects people's rights. And quite often CCAA relief is very, very practical. When courts approve plans or take other steps, they look at the reality of the situation. And I know certainly in those cases I just cited, there was often a debate where you had the investment structured one way, but when an insolvency occurred, the originator or somebody else attacked the structure and said, no, this isn't compliant, therefore it should be treated differently, or the debt is not enforceable. And in the cases I've cited, of course, the courts said no. And for example, in East Cameron, the court said this is a true sale situation, and we're going to allow people to exercise their rights accordingly. My view is the Canadian courts would do the same thing. They would look at the structure practically. They would carry out the commercial intent of the parties at the time the transaction was entered into, and they would not be very receptive to the technical arguments that we've seen in these other kinds of cases. So to wrap up, there's a very, very strong insolvency regime in Canada, and I think that any sukuk could certainly pursue its recourse fully in Canada, and that should give a comfort to anybody who's setting up one of these structures or anybody who is investing in them.
Thanks, John. I think, simply put, in what we wanted to establish here was that whether you're looking at it from a securities law perspective, or looking at it from a leasing perspective, or looking from an insolvency, we have robust regimes in Canada. So does the U.S., so does the UK. So the message to the world, the Islamic world, is Canada is ready to deal with sukuk in a manner that everyone can feel very comfortable of how these things would play out, more or less, with established jurisprudence and otherwise. And in contrast to other jurisdictions that may not have these robust laws and rules, and there's uncertainty, which is not what a bondholder, sukuk holder wants. They want to know what they bought, whether it's secured or unsecured, and how it will play out. But what I'd like to do now is ask the gentleman at the back if they could put up Deloitte's presentation. And the front-end analysis that in terms of taxation issues, I wanted to ask John to look at, because most importantly, everyone is seeing dispositions and purchase undertakings and sales and puts and calls and all these things, and things are moving back and forth. And we have to deal with provincial tax, federal tax. How do you structure these things? And I've been happy to work with John and Deloitte. They've done a few of these already, so they have some very good insight on how these are doable in Canada. On a sovereign level, a sovereign simply is left with either, it also, in certain circumstances, has to deal with taxation issues and or change the law. But with that, I'll hand it over now to John.
Great. Thank you, Brian. So what I'll do in a few minutes is just really try to hit the high-level principles in here. It's not intended to go through the detailed tax analysis, because there are a fair number of bells and whistles on here, but at the core of it, it's pretty simple. A couple of the key messages here, just before I go through a couple of the examples, is that so far, everything that we've seen, there has been tax answers for absolutely every single structure that we've been looking for. So there's really nothing magical in here. In fact, all of the tax answers are really conventional Canadian tax answers that are really applied into an Islamic finance situation.